May it please the court, Joyce Lindauer here on behalf of Mingtel Incorporated. We were the defendant in the district court. We're the appellant in this court. This case should be of some interest to the judges in the Fifth Circuit because it does involve a law that there's not a lot of case law on, which is the United Nations Convention on Contracts for the International Sale of Goods. As the court's aware, this is a... I'm sorry?
Suggesting the Fifth Circuit is particularly interested in writing in lonely areas of the law?
Well, no, I think given the international trade that is going on around the world these days, I think you're going to see more issues arise under the international sale of goods provisions. The parties both agreed that that was the applicable law that applied to their relationship. And I do think this is an interesting case because you do have an American company that contracted with a Chinese company to purchase tablets, small computer tablets from China. And I do think you're going to see these types of issues more frequently before this court. This case, I think, raises some unique questions regarding how you apply the provisions of the Convention on Contracts for the International Sale of Goods, which is part of the reason that my client asked that we appeal this, because he is in the business of buying goods outside the United States and bringing them into the United States. This case raises some, what we consider, serious questions regarding things like notice, timing, non-conforming goods, defective goods, and the relationship between the parties. As I mentioned...
Let me ask you.
Sure.
Right to the heart of things. Is there any reason these tablets could not have been inspected before they were sold to customers?
Well, if you read the briefs and the facts and the findings made by the district court, the tablets were inspected in China, as the record reveals. The problem was that the tablets, while they could be inspected in China, they couldn't be tested in China for Wi-Fi capability and things that we have in the United States. The troubling issue here is that Shenzen, the seller of the tablets, knew, because remember there was a 3-year relationship between these parties, this was not their first rodeo with each other, knew that the goods were being shipped to the Home Shopping Network, to HSN.
Maybe, Judge, maybe to put a finer point on Judge Wiener's question, we all understand that the Wi-Fi, United States Wi-Fi capabilities couldn't be tested in China, but when they were shipped to Mingtel in the United States, could they not have been tested before being sent to the Home Shopping Network?
They could have been tested possibly at Home Shopping Network's location, their warehouse. Here's the problem, though. If you read the testimony carefully, which I know you have, is the defects in the tablets were not immediately identifiable. If you read what was happening with the tablets, they were not properly connecting through the internet. Now that is something you probably could have identified fairly quickly, but there were also problems with the screens, and the testimony was that sometimes it would take several days before the problems would actually develop. So if you went to the Home Shopping Network warehouse, you pulled a box of these out, assuming you could connect to the Wi-Fi at their location, for maybe 30 minutes, that tablet may function fairly well. The problem is once it was sold to customers, the customer complaints were that within a day or two, the screens went dark, the screens were scratchy, and then it stopped connecting, or the connection was very slow.
Counsel, I don't think you're saying this, but I want to make sure. Are you saying there's a fact finding from the district court that we know what the problem with the tablets were? Do we really know that? Is there a fact finding on that?
I think that there was a fact finding that I'd have to go back and read the court's opinion, but I don't think there was a specific fact finding on exactly what the problem was. I think there was a fact finding on what the contentions with regard to the problems were.
It could have been, we know there were problems because they weren't being sold on
Right.
HSN, and they were returned. Many of them were returned.
Right.
But we don't know, I don't think we know from a fact finding in the district court what the nature of the problem was. Was it a problem with the tablets themselves, or was it something
So if you
something
look at,
else?
if you look at finding 23, it says shortly after the HSN sale, Mingtel received generalized complaints from HSN and customers regarding defective issues with the tablets. Specifically, Mingtel received complaints about the tablet's slow processing speeds and issues with the screens. So those were the two defects, if you will, that were identified at the time of trial. I tried the case. We actually gave the judge tablets to look at, to boot up in the courtroom. There's no mention of that in his decision, to show him how slowly these tablets were running.
But slow, yes, but there has to be a reason why they're slow.
Right.
And there could be a multitude of reasons, or many reasons,
Right.
why something is not booting up.
Right. And if you read the facts, the court did make the fact finding that both parties were aware there was a problem, that Mingtel told Shenzen there was a problem. Shenzen was proposing fixes. They were saying, well, let's do some software patches. Let's do some fixes. Let's do this. Eventually, Shenzen says, we can't fix the problem. That was the ultimate conclusion from the testimony.
Finding and legal conclusion by the district judge after a bench trial, as you well appreciate, this isn't
Right.
of summary judgment. There actually was a bench trial, so he had the facts, or the judge had the facts in front, and says Mingtel has failed to demonstrate and examine the goods that caused them to be examined within as short a period as practicable. And then the judge gets into even upon delivery at the HSN warehouse, Mingtel failed to examine the tablets then and had not examined them earlier. I mean, it seems to me that you're fighting against the evidence that the district judge has already made a finding on, that it was not examined as promptly as this UN convention says it needed to be. And so that's both a legal conclusion and a factual finding. But he looked at your evidence. You're talking about, well, it took a while for some of this to manifest itself. Imagine if that was in front of him. Who was the district judge?
Oh, Judge, is it
I don't know
Mazzetti?
if I'm using the right pronoun.
I think it's Judge Mazzetti.
Bazant.
Whoever it was,
Yeah.
before the district judge. And so those were the battles in front of the district judge, and not here, it seems to me, unless you have some legal argument as to why that's a misreading of the law and of the convention.
So let me, getting right to the bottom of it, let me tell you our biggest concern is the question of notice. That seemed to be what the court focused on and what you're focusing on, which is the question of notice. Now, look, there's no dispute that both parties knew there was a problem with the tablets, right? That's undisputed. And that both parties were trying to find a solution.
Both parties were eventually aware.
Right.
They weren't aware soon enough, and whose responsibility is that as part of
Right. Right.
the trial was supposed to get to the bottom of.
Right, but here's the frustrating part of this. Under the Convention on Contracts for Goods, as you alluded to, there is that provision that says you're supposed to provide notice, right, specifying the nature of the lack of conformity within a reasonable time after it was discovered or ought to have been discovered, right? Then if you look at Article 39, Paragraph 2, it says at the latest within 2 years. Well, we all know there is no 2-year issue here. They were notified well before the end of 2 years. What we take issue with is the court finding it was about 2 to 3 months between the delivery to HSN, the sale to customers, and the complaints. We don't think 2 to 3 months is an unreasonable period of time. The district court found that he thought it was an unreasonable period of time. I don't think so.
Well, is that a fact issue or a legal issue? Whether
I think-
sounds factual to me.
I think the facts of notice is a factual issue. The application of that section to the facts, I think, is a legal issue in the sense that the court made the legal determination that 2 to 3 months related to electronics, as we have in this situation, was too long. His finding was
if you
that
want
the
me to
notice,
reverse that,
I'm sorry.
if you want us to reverse that, do we have to say that that's a clear error or just an error, de novo?
I think it's just an error, And I
Okay,
think,
why is it an error then?
because I think that what the United States Convention says, and this is, I think people kind of ignore this, is you're supposed to interpret it, this is Article 8, according to the intent of the parties, what they knew or could have been aware of, and what their course of dealing was. So let's go back. There was 3-year history before the transaction number 60 that caused all the problems, right? So these parties had been buying and selling together for a period of time.
Okay, is
And
there something in
apparently-
their course of dealing then that would show that the 2 to 3 month notice was not unreasonable?
Right, but...
No, that's a question.
But the point is I don't think there was any evidence to show that a 2 or 3 month period of time was unreasonable. So there wasn't any evidence to the contrary.
Whose burden was it?
I think it would probably fall on the defendant, that it would be our burden to show that
Okay,
we
so if there's
notified-
no evidence, then that means you lose if it's your burden.
No, I think there is evidence that 2 to 3 month delay was not unreasonable
Okay,
when
what
the
is it?
parties are working to try to fix a solution.
Okay, well, what is the evidence that the 2 to 3 month period that the district court found was not reasonable notice? What's the evidence that contradicts that?
The fact that Shenzen never complained that the 2 to 3, and in fact, both parties seemed to be working during that 2 to 3 months to try to find a solution. Shenzen didn't immediately say, you're too late, sorry, non-conforming goods, not our problem, you've already paid for them, your problem. Contract 60, I think, is problematic on the notice issue. I think that the court implied a finding or conclusion that 2 to 3 months was too long based on what I don't know. We don't know exactly why the court said that, but it seems unreasonable when you're dealing with electronics. We're not dealing with pork.
Depends on the evidence, it seems.
Right.
And you would be a whole lot more familiar with the evidence, at least, than I am. Judge Duncan may have dug into everything that appeared at the bench trial. But the convention actually says as quick as is practicable.
Right.
Not as is practicable. So what was practicable? And it seems to me a finding like that by the district judge would require finding of how soon would this problem on these tablets been discovered if your client had done something before they went off to the home shopping network or whatever those letters stand for. And so whatever that evidence mix was, the district judge says it was practicable to give this notice sooner.
Right.
And that to me is a fact finding.
Right. Well, Your Honor,
It has to be rebutted by you.
Right.
By the evidence that's in the record. No,
Right.
there's no evidence that even if they'd spent a week looking at these tablets before they went to home shopping network, that these problems necessarily would have derived. And I imagine there's some evidence like that, and the district judge, to me, just did not buy that your client had done enough before allowing them to go out to consumers. That's how I read this. Is that he could be wrong, but that finding could be wrong, but isn't that what the judge was holding?
That's pretty much what the judge said, and we disagree with that finding. Obviously, that's why we're here. But the other issue is the second contract, contract 59. So we have the first contract, which was fully paid for, performed, goods delivered. The complaint was that the goods were defective and non-conforming, okay? All right, here's what's troubling to me. Even if the notice wasn't sufficient, there is no dispute that there were problems with the first shipment, right? We know that. The parties were trying to fix it. So you say, okay, you didn't give sufficient notice on 60. You should have gone out there, you should have opened the cases, you should have tried them, you didn't. So we're not going to give you a claim for non-conforming goods. But then we look at contract 59 and my client says, but wait a minute, I got bad product here. You even admit there are problems with the product, right? And so then we go to shipment 59 and my client says, well, look, I don't want to take another shipment of bad products. I should have the right, based on what happened over here, to be able to reject 59. And the district court said, no, you can't use the non-conforming products over here, even if they were non-conforming. The court found they were not non-conforming because of the notice question, which is in some ways baffling to me because we know there was a problem with these products. Yet when we get to contract 59, you're basically telling my client, you have to buy them anyway. You have to buy them if you know they're junk and they don't work. You can't reject contract 59 because you got bad product on contract 60. 59 should stand on its own as to what happened. My client rejected 59, said, I don't want more of the same problem that I have with 60. Synging knew there was a problem with 60. They tried to fix it, couldn't fix it. My client then is forced to take 59. And there are other issues there too. How many pieces? You know, okay. I'm past time.
Your time.
Okay, thank you, Judge.
Time on rebuttal, and your brief
Thank you.
addresses all that as well.
May it please the court, Robert Becerra on behalf of the appellee. Going back to the...
On what your friend on the other side was saying at the end, what notice, as the record show, was given after the problems with the first shipment to cancel the second shipment before it came, or to object to it, or whatever?
Well, I believe that Mr. Chan testified that really the first time he ever was cognizant of a real problem like that is when he advised Mingtel that he had made 5,000 tablets that were ready to be picked up out of the 10,000 order on Order 59, and in response they said, we're not going to pick it up, and by the way, don't manufacture the other 5,000 because we've had problems with your tablets, we don't like them.
Notice having been given by the other side in advance of that they don't want to take this second shipment.
Well, Judge, I mean, it's very, as the court found below, it was very little wishy-washy about exactly when notice was given, but I will tell you what we do know. What we do know from the trial record is that Mingtel did not test any of these tablets until it had already gone to HSN. HSN had sold it to the public had returned them, and then HSN returned them to Mingtel. That didn't happen, and there was testimony from Mr. Hugh in response to the court's own questioning that he did not test himself, or Mingtel didn't test the tablets until April 2018. So we're talking about, this is several months until after the tablets were shipped, and I could try to find in the record where that was, Your Honor. And here, in record on appeal, page 831, he indicates to the judge that, you know, I did some testing. By the way, the big complaint on that from Mingtel regarding the tablets is that they were slow. So he did testing in April 2018 in response to questioning from Judge Mazant regarding, hey, did you do tests? And he goes, I did them in April 2018. That's on.
What was the evidence at trial of how difficult it was to test and have this problem manifest itself? Because one of the arguments, it seems to me, in this case is that even if they had done something before shipping them off to the Home Shopping Network, they would not have discovered how slow it is. It's aberrational when the problems arise. I'm making things up. Something like that. I think is
Judge, I mean, our position is that, I mean, I'm sorry.
The difficulty of testing these tablets.
Judge, our position, you got to remember, in this case, I mean, the parties already had, part of their course of dealing is that they did inspect. They inspected at the plant in China, and one of the things they did was turn on the Wi-Fi, and it worked in China. So they both know now, both parties know that that doesn't mean it's going to work in the United States. So what happens is that all they had to do to test it in China was turn it on and connect it to the Wi-Fi, to the internet in China. They could have done the same thing, and remember, Mingtel picks this stuff up. They're the ones who are in possession, custody, and control from day one that this stuff leaves China.
Some other contractor on their behalf.
Right, but they're in custody, they're in control of the shipment. Yeah, they're in control of the shipment, Your Honor, and so they decide. Yeah. What I was saying is that they're deciding like when and where they can have. You know, the shipment could have stopped in Los Angeles. They could have turned it on there, connected it to the internet, and tested it.
Okay, but what I'm asking is there evidence at trial that if they had turned it on in L.A., turned it on wherever else, that it would not necessarily have been a problem? That these problems manifest themselves slowly, aberrationally, regularly? Was that part of the evidence?
No, there was no evidence as to that. As a matter of fact, the evidence regarding all the evidence was that it's slow, And one of the things that was in cross-examination and during the examination of the witness is that even the witness had to admit that how slow was in the eye of the beholder, that it was a completely subjective standard. They had no expert testimony that how slow is too slow, how slow is acceptable.
I mean, so this is kind of what surprises me is this is a technical case, and yet we're sitting here talking about like I'm talking with my mother. Oh well, it's slow. Wasn't there an expert in the case who said, you know, I've examined this, and actually the problem is insert technical gobbledygook for what the problem is, so we can understand what we're talking about, as opposed to, well, they're slow.
Yeah, there was no testimony at all as to that. The defendant had the burden of proof to prove nonconformity, and all they could say is that it was slow. How slow? And counsel mentions that they brought some of the tablets into court, and the trial counsel in front of the judge booted it up and connected to the internet using those tablets. You know, but they're slow. I mean, so it's a very arbitrary, subjective, and like I said, the defense witness, you know, agreed that it's all in the eye of the beholder.
So my question, I guess backing up a little bit from when the problems manifested themselves, back to this was a contract for a particular tablet. There were specifications in the contract that the parties agreed to, correct?
Yes, there were specifications.
And there was something called a golden sample that was viewed by the parties, and they agreed on all this stuff.
That's correct. The golden sample was provided. It was agreed to. Then, when the lot was actually manufactured, Mingtel's own inspectors went to the factory and taking random samples of the stuff they were going to be shipped or delivered. They turned it on. They submitted written inspection reports that are in evidence that passed the tablets.
Was one of the specifications this has to work in U.S. Wi-Fi up to a certain speed or something like that?
There's nothing in the record. None of the bill of materials, the contract, nothing is there that indicates a specific speed that was required under the contract. And that's one of our points: is that, you know, to say it's non-conforming to what? You know, if it had said that this must boot up in 5 seconds and then it didn't, maybe you'd have an argument, but there was no specifications like that. I mean, my computer this morning was a little slow. Is it non-conforming? I can't say that.
We don't have any such problems here in the federal courts.
Right. But that's why I would submit that the findings of fact by the court were not clearly erroneous. They were adequately supported by the record, by the admitted exhibits below, and as such, we'd submit that the amended final judgment of the court should be affirmed by this court, that basically the defendant did not shoulder its burden of proof, number one, to prove it was non-conforming. You know, what they prove is that it was slow, but was that non-conforming? The judge said they didn't shoulder their burden of proof.
I mean, it sounds like everyone agrees there was a problem, right?
Right.
They were slow. Right. People weren't buying them on HSN.
Right. Now, that's another issue, is that the trial testimony and it also established that there were many reasons why people might return tablets that didn't have to do with it being slow, or, you know, people could return the tablet if they didn't like the color, if they didn't like the style. There was a number of reasons. So just the returns by themselves didn't mean by themselves that the goods were non-conforming. You know, it wasn't that, you know, there was no evidence that was admitted into the record that about the customer complaints. Why? Because it was all inadmissible hearsay. But what we do know is that there was a return rate, but exactly why it was returned, what was a particular reason, how many was because they didn't like the color, how many was because they didn't like the style, how many because it was slow, we don't know. The record's not there on that, and that's why the judge also found that the defendant couldn't shoulder the burden of proof.
Between the two parties, I guess Synergy and Mingtel, Synergy provided certain things. Did Mingtel also provide other things that went into the tablets?
That's correct, Judge. What they provided was something called Freedom Pop, which was a software for cellular data, and that was a non-Shenzen material or matter that was submitted into or loaded into the tablets, and that was one of the things that was actually complained about in emails submitted by the defendants themselves to HSN. They themselves blamed the Freedom Pop software for the tablets being slow. They actually sent emails to HSN saying, hey, we looked at these tablets, they're not slow at all. It can't be a tablet problem. It's got to be a connection problem. And that would be true. If you're in an area that had slow Wi-Fi or had a very bad cellular network, your tablet would be slow. It wouldn't load the internet properly. We never had testimony in the record from the defendant that's saying that the reason why that Wi-Fi was slow was exclusively because of a fault of the tablet being non-conforming.
You got anything else for us, counsel?
I have nothing else, Your Honors, just to say that as the appellee, we ask that the court affirm the final judgment below.
And I'll be brief. I want to focus on really the second contract. We really didn't talk too much about that, which is contract 59. Contract 60 was paid for. Those goods were delivered. I think everybody is aware there were problems with the goods, okay? What the district court judge said was, well, there may have been problems with the goods, but you didn't give timely notice, so we can't treat them as non-conforming goods. Therefore, you cannot use those goods as an excuse to not pay for contract 59. And we disagree with that. I think there was enough evidence in the record that there was a problem with the first order, and therefore we believe our client was relieved of the obligation to pay for the second order. The district court disagreed. He said, no, you made a deal with them, you have to pay for this. Now, let's remember on the second order, we never got any of those tablets. We never accepted delivery of any of those tablets. 5,000 tablets were built, not 10,000. There was a dispute over how much that order was actually for. We argued it was 5,000. They argued 10,000. The deposit showed 5,000, not 10,000. So the course of dealing between the parties indicated that
Isn't there a fact finding that the lower deposit was accepted because of cash flow problems?
But if you go back and look at the record, there's no evidence in the record to support that.
So you're saying that's clearly erroneous?
Clearly erroneous. And clearly the course of dealing between the parties had been 10% deposit. That was the deposit. And even Mr. Chan, on behalf of Shenzen, said 10% was the standard deposit. Our contention, Your Honors, we should have been relieved of the obligation to buy the second set of tablets. And the district court did not relieve us of that obligation. They said because you didn't handle the first order right, you don't get the benefit as it applies to the second order, and we disagree. A couple of issues I mentioned, the deposit amount, the 5% versus 10%. I do think there are some issues. There was a dispute over the resale of some of the items, that some of the tablets were resold. There was testimony for $30, some testimony for $60. Again, the court took the lowest of those, $30. The motherboards they claimed they purchased, again, the testimony on that I think was a little shaky on what ultimately happened with those. They never did testify what they actually did with the motherboards they bought. But again, this case is troubling to me because, just think about this, you bought crappy goods. Maybe you didn't follow all the rules. Maybe you didn't know the rules to follow, but you bought goods that had a problem, and then you go to the manufacturer and say, I don't want any more of your goods. You have my deposit, keep my deposit, we're done.
What if the problem was with the SIM cards that Mingtel provided and not the tablets themselves?
All of the evidence, well, if that were true, then why was Shenzen trying to come up with a fix, if you will? If you read the testimony, it's very clear that Mr. Chan testified over and over that they were trying to come up with a fix, a software update, some kind of a Band-Aid. They never said it was the SIM cards.
I'm looking, well, so Mingtel, here's an email from Mingtel's Vice President of Sales to Tim Curran of HSN. That is not a tablet issue, it's a Wi-Fi or network issue.
Okay, but let's think about this, okay? You're Mingtel, and you're selling to a customer, HSN, right? They have how many thousands of these tablets that you're trying to sell through the home shopping network, right? So you're trying to say, wait a minute, we don't think there's anything wrong with these tablets. It may be something else.
Are you saying the email is not truthful then?
I'm saying the email is not truthful. I think the testimony was that the email was just like it sounds. It was a pitch to try to encourage the home shopping network to continue to sell the tablets to the public. It was like, look, wait a minute, we're going to try to fix this, whatever. Again, that is not an email between Shenzhen and Mingtel, right? It's not an email between the parties. That's an email with a third party, and that's from a salesman.
But it's evidence.
But I know, but it's from a salesman at Mingtel saying, hey, wait a minute, guys, calm down. It's going to be okay. We think it's something else, right? Ultimately, 37% of the goods sold were returned. Not even half of the goods ultimately were ever sold. And again, I have to focus not so much on order 1, it's on order 2. Knowing all of that, how can you say, I am obligated to buy order number 2? I should have been relieved of the obligation. Look, keep my deposit. That's fine. You got my deposit, that's fine. But I should have been relieved of the obligation on the purchase order 2. Thank you, Your Honor.
All right, counsel. Thanks to both sides for bringing your arguments to us. We'll take a brief recess before hearing the last case of the